Hello, and thank you for visiting Graphene Business Law. If you're a small business owner that's ever wondered about how a conversation you've had may have impacted you entering into a contract with somebody, if you've ever wondered, hey, did I just agree to something that I might not necessarily have wanted to or have known I was agreeing to, or if you've ever had somebody knock on your door saying, hey, here's that deal we talked about, here's that order you requested, and you've thought, what? Well, then this video is for you. In this video, we're going to discuss the applicability or viability of oral contracts entered into in Ontario. My name is Pamela Matani. I'm the lawyer and I'm the principal lawyer and founder here at Graphene Business Law, where of course we serve small businesses and entrepreneurs, and that's the only thing we do. We're able to assist you virtually across Ontario. And as pertains to this YouTube channel, we regularly post content that would be most beneficial to you as entrepreneurs and business owners. And we also have other series here for students and other demographics, but let's delve into the video now. So with oral contracts, the scenario that kind of drives this is one where, hypothetical by the way, is one where, let's say you have a storefront. Somebody knocks on your door. Hey, lovely storefront, but I know a way to make it better. I'm a local artist and I could paint you a mural of, this beautiful, whatever you're in the business of. If you're, a barber, let's say this beautiful, comb and brush and a razor kit, okay? And you say, man, that sounds really cool. Yeah. And he says, yeah. So I could come next weekend, before you even open up, I'll have the mural up and, $1,000 or $2,000. Sounds good. That's what you say. Now you show up next weekend, he's taken you seriously. He's drawn this, beautiful, like super lifelike mural of, brushes and combs and scissors and razors and whatever salons use and barbershops use. And now he's done his end of the deal and he's saying, so the 2,000? And you're going, what? So that's the example we're talking about. That's a fairly innocent example, but it's a really good one to start this video with, because that's, how people risk entering into oral contracts every day. Every day. These conversations happen about, well, wouldn't this be nice, or wouldn't this be good, or hey, can I help you with this? And those can be legally risky conversations. So now we're gonna peel it back and work through this example as we go through our video. First thing we're gonna look at is and I'm just pulling up my notes here, is does a contract have to be written in Canada to be enforceable? And specifically, again, Graphene Business Law, we service clients in Ontario. So does the contract have to be written to be enforceable in Ontario? Despite what many people assume, the technical answer is no. Contract does not have to be in writing to be enforceable in Ontario. Oral contracts can be legally binding. It doesn't mean they're the best kind of contracts. It doesn't mean they're the kind that somebody will recommend you enter into. But just so you know, there is a risk that hypothetical we started the video with, hey, I offer you this service and you say, sounds good, can become something more than you might have envisioned it to become, can become something that you need to protect yourself against or you need to know about. There's contract types that simply can't be entered into orally in Canada, for example, the conveyance of property, but that's outside of the scope of this video anyways. We're talking here about, you're a business owner, you work with sellers, you work with buyers, you work with partners, you have some intellectual property, like the things that keep your business running on a daily basis. And the fact that every day there's an opportunity for you to enter into an oral contract without you even knowing, and that's why you should educate yourself. Looking at the elements of an oral contract, how will one stand up in court? The same way a written contract would. And factors we're looking at there are an offer made either to you or by you, acceptance of an offer, consideration. And we're not talking here, being considerate, like in the feeling sense. We're talking about business consideration, otherwise known as value. And the last step is an intention for parties to enter into legal relations. Let's go through those, and keeping, again, our hypothetical in mind. It's an innocent hypothetical. There are much more severe hypotheticals I could have used, but I think it's one that still gets the job done in terms of communicating to you, somebody that's curious or maybe nervous about having entered into an oral contract and what you need to know. It's a really good starting point of a hypothetical. Where that guy knocks on your door and says, hey, nice front wall, but I can make it better. And I can make it better by doing this for you. That might be seen as an offer. He offered to paint you this mural on the facade of your building, on that front brick. You said, yeah, sounds good. That certainly can constitute acceptance. You've literally just communicated that yes. Consideration. Value that we talked about. What value is he giving? What value are you giving? Did both parties just give a value or intend to give a value or agree to give a value? Well, he's saying, I'm going to paint this lovely mural of a razor kit. Whatever. That's his value. And you, somewhere in here, can be seen to have just accepted to pay him $2,000 for his service. So his value is service, your value is money. Maybe consideration applies here too. Then we look at the fourth part, intention to enter into legal relations. And this is inherently the trickiest part of this formula of how can an oral contract stand up in court. Because we can point, if you rewind this video to the beginning of the hypothetical I provided, you can point to the words I have just said, the same way you'd be able to point to the words that somebody else said in front of you if you had a conversation with them that morning. Okay? So you can point to the offer, you can point to the acceptance, you might be able to point to the consideration. But how can you point to intention? That's arguably, that's the reason these things end up in court, because somebody says, whoa, for me, this wasn't serious. And then the judge is going to have to go through these things. The decision maker is going to have to go through whatever, ingredients to the pie you're providing him, and he's going to have to go through one by one. Well, could, Mohammed watching this video, the business owner, have really intended to enter in this conversation, Like how, was Mohammed thinking about a mural? Was Mohammed wanting a mural? Did Mohammed have money to pay for the mural? If the mural you were quoted $2,000, but you've got $600 in your business account, or if the mural was $2,000, but you've got $3,000 in your account, would you have just emptied 70% of your account just because somebody walked into your door with a cool artistic idea? Like, there are, whatever evidence exists and is presented to that judge, they're going to have to look at, and they're going to make a decision. Might not be one that you like. Might be one that you like, but the other party doesn't, right? Like, it's going to be decided one of two ways. But the big picture here is not to, take notes on the things that the judge can say. The big picture here is, why are we in this setting in the first place? Again, technically, yes, oral contracts can be entered into, but should they? Because a lot of things technically can happen out there, but a lot of things technically are not a good idea in real life. And I don't think I've ever read a case that said entering into an oral contract is a good idea. I haven't read one that says that, okay? And again, from a legal information perspective, I'm not giving legal advice here. I can't do that unless you're my client. But from a legal information perspective, you take that information and you use it as you please as a business owner. I'll also tell you, because I suspect if you're watching this video, if you've done some research on the internet, you might have come across this principle called Parol Evidence Rule, and I'll spend a few minutes in this video kind of very high level untangling that. If you've come across that term, Parol Evidence Rule, what we're talking about here is not an agreement made from scratch, orally, verbally, all the way. We're talking about a scenario where there's a written agreement and something verbal goes against it. Big picture, right? You might go against it 1%, 2%, 100%. So we're not getting into that. Big picture. Verbal goes against the writing. Supreme Court of Canada has decided, case was Horish and Montreal, or Bank of Montreal. That's one of the cases where it's been decided, refuse the verbal at all costs. There's exceptions to that. There's been exceptions to that. ever since. And, you know, some of these exceptions include when the oral agreement doesn't conflict with the written document. But somebody, you know, arguably in a real life setting would only be coming back to the written because they saw something there they didn't like, and now they're trying to amend it verbally, right? So I don't know how useful that case might be for your circumstances. There's also a case, Briars and McMillan, where the ratio of this one, or by ratio I mean what this case stands for, is a little funny for me as a lawyer because it rewinds this video all the way back to the opening segment, and it's, you know, that oral contract could be seen as viable. That thing you've described or agreed to orally after the writing could stand as an exception to the Parol Evidence Rule, and it could stand as something that can be enforced in court if it could stand as its own agreement, an independent agreement with no relation to the written. And again, that brings it back to the first part of the video of how do you enter these oral agreements in the first place, which we discussed the 4 big picture ingredients there. But also it brings it back to the part in the video where we talked about who said this is a good idea, just because technically it's possible. When something is oral, when something is verbal, there's 100% that risk there that someone is going to say, that's not what I said. Whether because they've decided they no longer like what they actually said, whether it's because they don't remember what they said, or for any other circumstance in there, you know, maybe they didn't want to say what they said in the first place, for any reason. There is always that risk with verbal contracts. And if you're a small business owner, or if you're an entrepreneur just starting out, I understand, you know, I see it all the time. There's worries about putting something in, in writing. Might be scary, might seem intimidating. You might think it's costly, but you don't know how costly it's going to be to undo whatever mess you get into verbally if it becomes, a mess. And the chances of it becoming a mess are really, really, really high. So that's the gist with these oral contracts, It's not that they can't be entered into, but is it a good idea? It's not that they can't be enforced, but if you're in a mess where you're fighting for what you said to be enforced, you're in a court setting, right? Like, that's the only way you're going to have a third party comment on this, and it's going to be that judge. And how costly and how time consuming it's going to, I wish it was timely, how time consuming it's going to be for you to get to that answer is not worth the risk of having entered into a verbal contract to begin with. As a last comment on the video, I want to point out that big picture again, you might be thinking, well, what are the ways I could enter into these verbal contracts? Am I entering into one without even knowing? Big picture, there's 2 ways. One is the unintentional, one is the intentional. The unintentional scenario is what I call the nice guy scenario, okay? And that's one where, the Muhammad example, he just says yes to everybody. He's so scared of hurting somebody's feelings, hey, would you like this? Yes. Can we do this? Yes. How about this? Sounds good. The conversation there is not a legal one. That's like a human to human conversation, and that's a business conversation maybe as well. Don't say yes to things you don't want to say yes to. Don't agree to things you don't want to agree to. Don't say sounds good. Don't enter into, nothing affirmative or positive if that's not how you genuinely feel. Or if you can't, maybe an idea sounds shiny, you can't fund it, there's no way. Don't sign up for things you don't wish to sign up for, and the signing up of which you can't back up, okay? That's again like a human conversation. On the law front, if you intend to enter into a contract with somebody and you're thinking that oral might just be the quickest thing, we have a phone call, 30 seconds, it's done, no need for papers, no need for lawyers, no need for money, or financing, the official agreement, that's one where I really encourage you to think again. Because as the saying goes, an ounce of prevention is worth a pound of the cure. And it's exactly meant for scenarios like this, okay? So that's one where I encourage you to think, you know, if you're entering into a contract that you're so excited about, that can further your business interests so much and do something so good for you, why would you not want to enter into this contract, you know, in a legally adherent manner that protects you as much as possible on that piece of paper you can point to, right? So if something matters enough, it's going to matter enough to do it right. And that's where I'll, you know, leave it with those two worlds of unintentional, nice guy, intentional, but needs to think a little more. Okay. Thank you for watching this video. Graphene Business Law. Again, this is what we do. We are more than happy and capable, more than happy to help and more than capable of helping you with, you know, written agreements in place for your business, whether you're buying something, selling something, partnering with somebody, whether there's intellectual property at play, non-disclosure agreements, new employees, you know, whatever the case may be, we're here to help and further your interests. You know, if you're the one watching this video, we're here to help you. So info@graphenebusinesslaw.ca if you're looking to email us, and our website with all this information, graphenebusinesslaw.ca. Thank you for watching.